The relentless Illinois summer pressed down on Willow Creek Estates, a manicured expanse of identical beige townhouses and meticulously trimmed hedges, like a heavy, humid blanket. Within the seemingly idyllic landscape, a storm was brewing, a tempest of injustice that swirled around my sister, Clara, and the property she'd inherited, a modest, slightly quirky townhouse with vibrant, overgrown garden that was a stark contrast to the HOA's rigid aesthetic. Clara, a free spirit and an artist, had always been at odds with the Willow Creek Homeowners Association. Their rules, their regulations, their constant nitpicking letters, they were a source of perpetual irritation for her. She preferred the chaotic beauty of her garden, the mismatched furniture she collected over the years, the art projects that spilled out of her garage and onto her driveway. The HOA, on the other hand, preferred uniformity, conformity, and absolute adherence to their meticulously crafted bylaws. When Clara tragically passed away, leaving the townhouse to me, her only brother, I knew I was stepping into a minefield. I was a lawyer, a pragmatist, a man who believed in order and due process. I was also, however, fiercely protective of my sister's memory and determined to honor her wishes. The first letter arrived a week after the funeral. It was a curt, impersonal notice about unpaid HOA dues. Clara, bless her soul, had been notoriously bad at paperwork. I knew she'd fallen behind, but I'd assumed we'd settle the debt when the estate was finalized. The letter, however, suggested otherwise. It demanded immediate payment, along with late fees and penalties that seemed exorbitant. I called the HOA's management company, a faceless entity called Community Solutions, and spoke to a woman with a voice as sharp as broken glass. I explained the situation, offered to provide proof of my status as the executor of Clara's estate, and asked for a reasonable payment plan. The response was a cold, robotic recitation of the HOA's bylaws and a firm refusal to negotiate. "The dues are past due, sir," she said, her voice devoid of any empathy. "According to our records, your sister was notified multiple times. Failure to pay will result in further action." "What further action?" I asked, my voice rising. "The HOA has a right to place a lien on the property and, if necessary, foreclose on it," she stated, as if reading from a script. I was stunned. Foreclosure? For a few $1,000s in unpaid dues? It seemed excessive, even predatory. I knew that HOAs had the power to enforce their rules, but I'd always assumed there were limits, safeguards. I immediately began researching Illinois law regarding HOAs and foreclosures. What I found was a complex web of statutes and regulations, a maze of legalese that seemed designed to protect the HOA, not the homeowner. I discovered that HOAs in Illinois did indeed have the right to place liens and foreclose on properties for unpaid dues. However, there were strict procedures that had to be followed, and a failure to adhere to those procedures could invalidate the foreclosure. I also found something else, a detail that the HOA seemed to have overlooked, a crucial element of the Illinois Condominium Property Act, which, while focusing on condos, provided guidance for planned communities and HOAs regarding notification and due process, especially in relation to the sale of the property due to unpaid dues. The next few weeks were a whirlwind of legal research, document gathering, intense phone calls with Community Solutions. I sent them certified letters, demanding proof of the notification sent to Clara, requesting a detailed accounting of the dues owed, and reminding them of their obligations under Illinois law. I even managed to find a copy of the original bylaws of Willow Creek Estates, a dusty, yellow document that revealed a few interesting discrepancies. The HOA responded with more form letters, more demands, and more threats. They were clearly determined to bulldoze their way through this, confident in their power and their ability to intimidate. I, however, was equally determined to fight. One morning, I received a call from a real estate agent. He informed me that the HOA had sold Clara's townhouse. It was a done deal. The property was no longer mine. I felt a cold dread wash over me, a sense of disbelief that they could actually go through with it. I immediately contacted a seasoned real estate lawyer, a formidable woman named Eleanor Vance, known for her sharp intellect and her willingness to take on difficult cases. I explained the situation, showed her the documents I had gathered, and pointed out the potential legal flaws in the HOA's actions. Eleanor listened intently, her eyes narrowing as she reviewed the paperwork. "They move fast," she said, her voice grim. "Too fast." She explained that while the HOA had the right to foreclose, they had to follow a specific process. They had to provide proper notice to the homeowner. They had to file a lawsuit. They had to obtain a court order. And most importantly, they had to ensure that the sale was conducted in a commercially reasonable manner. "Did they do any of that?" she asked, her eyes fixed on mine. "I don't think so," I said. "They just sent letters and then sold the property." Eleanor smiled, a thin, predatory smile that sent a shiver down my spine. "Then they've made a grave mistake," she said. "A very grave mistake." We immediately filed a lawsuit against the HOA, Community Solutions, and the new owner of the townhouse. The lawsuit alleged wrongful foreclosure, breach of contract, and violation of the Illinois Condominium Property Act. We demanded that the sale be rescinded, that the property be returned to the estate, and that the HOA be held accountable for their actions. The lawsuit sent shockwaves through Willow Creek Estates. The residents, accustomed to the HOA's iron-fisted rule, were stunned to see someone challenging their authority. The HOA, however, remained defiant. They hired a high-powered law firm and prepared to fight tooth and nail. The legal battle was long and arduous. We spent months in depositions, interrogations, and court hearings. We presented evidence of the HOA's failure to provide proper notice, their disregard for due process, and their questionable handling of the sale. We argued that the sale was conducted in a commercially unreasonable manner, that the property was sold for far less than its fair market value, and that the HOA had acted in bad faith. The HOA, on the other hand, argued that they had followed all the necessary procedures, that Clara had been properly notified, and that the sale was conducted fairly. They claimed that I was simply trying to avoid paying the dues that were rightfully owed. As the trial progressed, we uncovered more and more evidence of the HOA's misconduct. We discovered that they had routinely ignored their own bylaws, that they had engaged in selective enforcement of their rules, and that they had a history of bullying and intimidating homeowners. We also discovered that the new owner of the townhouse was a close associate of the president of the HOA, a fact that raised serious questions about the fairness of the sale. Crucial detail, however, the one that ultimately turned tide of the case, was the HOA's failure to comply with the notification requirements of the Illinois Condominium Property Act. While they had sent letters to Clara's address, they had failed to provide notice to the legal representative of the estate, namely me. This oversight, seemingly minor, was a fatal flaw in their case. The judge, a stern, no-nonsense woman named Judge Thompson, was unimpressed with the HOA's arguments. She ruled that they had failed to provide proper notice, that the sale was conducted illegally, and that the property must be returned to the estate. She also ordered the HOA to pay my legal fees and to compensate the estate for any damages incurred. The victory was sweet, but it was also bittersweet. Clara's townhouse was back in my possession, but she was still gone. The fight had taken a toll, but it was worth it. I had honored my sister's memory and held the HOA accountable for their actions. The aftermath of the trial was chaotic. The residents of Willow Creek Estates were divided, some applauding my courage, others resentful of the attention I had brought to their community. The HOA's reputation was tarnished, and their authority was weakened. The president of the HOA resigned, and the management company, Community Solutions, was replaced. The new HOA board, composed of more reasonable and transparent individuals, began the process of reforming the bylaws and restoring trust within the community. I decided to sell Clara's townhouse, but not before I had restored her garden to its former glory. I wanted to honor her memory, to create a space that reflected her spirit and her love of life. I hired a landscaper, a young woman with a passion for unconventional gardens, and together we transformed the overgrown yard into a vibrant, whimsical oasis. When the townhouse was finally sold, it was to a young couple who appreciated its unique charm and its connection to Clara's artistic legacy. I knew that she would have approved. The experience had taught me a valuable lesson about the importance of standing up for what is right, even when it seems daunting. It had also taught me that even the most powerful institutions can make mistakes, and that those mistakes can have serious consequences. The HOA had forgotten that one legal detail, the requirement to provide proper notice to the legal representative of an estate, and that oversight had cost them dearly. It was a reminder that even in the most complex legal battles, the smallest details can make the biggest difference.